give the permission to list the matter. There's a pending matter, but it was not listed. There is urgency. Can it be on 16? That is Friday, my lord. Highly on that.
Yes, ma'am. Item number 6. Actually, my lordship, I am suffering fevers, but so small earlier, my lord.
Ask someone to be here because an order matter, why it has been listed, we do not know. We'll just pass the order. Ask someone to be here. You can leave, no problem. So, Sonu, go to the stage. The prayer of the council for the petitioner. List on 22nd. Yes. Done.
Yeah, I beg to mention your item number 37 of today's list, lordship. This matter came up yesterday and your lordship has had my senior Mr. HR Chaudhary. So today this was fixed for.
We'll take up.
Lord.
Ask someone to be here.
Hello.
After the admission matters, we'll take up.
Lord. All right.
May it please your lordship. My lord, my humble apology, my lord, that on last item number 5, I could not appear. My junior appeared, my lord. My lord, there in the cost title of the name of the respondent, my lord, there's a mistake, my lord. Therefore, we filed one IA application yesterday, my lord. So along with this IA, may I pray, my lord, this matter to be taken on next Tuesday, my lord, subject to lordship's convenience, my lord. Because that defect will remain, my lord, even if lordship taken up this matter for disposal, my lord. So it will be, defect will be there,
21st.
my lord, obliged, along with that, obliged, deeply.
I beg to mention,
At 1 minute, my lordship. Actually, I will do my matter, my lordship. Small earlier, I want my lordship, because I want to stay order, my lordship.
No, we have fixed
Small
it on
earlier, because
22nd. So when do you want?
21, my lordship. So
21st is a many matters are fixed. That's the reason.
no, sir, I will do today, my lordship.
You want to do it today?
I will do because item number 6, my lordship. Small earlier, I want to the small earlier.
Okay. Okay.
Today I will do, sir.
Okay. No decision. Yes.
may I please your lordship, I beg to mention item number 7, my lordship. It was fixed for the scan copy of the LCR, my lordship. I've gone through the record, my lord, office note till today, LCR has not been received the scan copy, my lordship.
We'll pass necessary order.
So, my lordship, the respondent is also there, my lordship, and opposite party, my lordship.
We have to pass necessary order, not at the mention stage. Let the matter reach. Yes.
Mention for listing, my lord. My lord, it's a criminal petition, my lord. There's some urgency needed and it's been pending for so long, my lord. So some urgency is needed. So, my lord, may I fix it on Thursday or Friday, my lord?
It's a criminal petition,
Criminal petition, caution,
not this Thursday. When you last listed,
Friday, my lord.
when it was last listed,
It was last listed on 29, but it could not reach, my lord. 29th of July. It could not reach, my lord.
okay, on Friday.
Friday.
Yes.
May it please your lordship. Lordship, I beg to mention item number 14 as the conducting counsel Seema Bhuya having some personal difficulty, your lordship. So your lordship may kindly adjourn the matter for today.
If the order matters,
Yes, your
why
lordship.
it has been listed today, any idea? Wait for your turn, we'll adjourn it, but let the matter reach. Yes,
May I please, Lordship, I beg to mention item number 11, Lordship. The youngest concerned due to her illness could not appear for.
don't mention the order matters. We'll see. Don't mention the other matters. You need to pass certain orders. Yes.
May I please? Sir, with the consent of other side, I beg to mention item number 4, my lord. Kindly adjourn the matter 14 days.
The 2 weeks only to be fixed by the registry.
29.
We are not fixing any date. We'll be fixing a date and it will come on that date and thereafter you will be taking the adjournment. It will come after 2 weeks on a date fixed.
Yes, madam.
Yes.
May I please, your lordship? May I please, your lordship? Lordship, I beg to mention for listing of criminal revision petition for hearing, lordship.
It will not come for hearing. You have to first fix it for orders.
Lordship,
Then-
like, since January, it has been coming for hearing only, but either the petitioner are seeking time or either the matter doesn't reach. So lordship, kindly, it may be fixed
You
next
fix the
week.
matter for hearing orders first. Give us a date. When do you want for the order?
Lordship, any date next week?
22nd
Obliged, lordship.
May it please your lordship, lordship,
Ma-
I pray for listing,
orders. Yes.
pray for listing of a criminal petition, my lord. It was last listed on February, in the month of February, my lord, 9/2/24, my lord. Thereafter, it has not been listed, my lord. My lord, this matter may come up on 27, my lord, 27 August.
28, 27 is a hearing date.
Lordship, 28,
And then
29th, my
30th,
lord, 20
29th is again a hearing date.
Uh,
30th, 30.
30th, yes, ma'am. I'm out.
Yes.
Lordship, I beg to mention this matter, criminal revision petition of 28 from 222
For what? For
for
admission?
orders,
Okay.
28, 21st or 28.
22nd. Yes.
Lordship, I beg to mention for listing of a fresh IA criminal, your lordship. It is for suspension of sentence, your lordship, and bail. It was filed on 15th of July, your lord. So any convenient date for the honorable court.
Tomorrow.
May it
Much
please your
obliged.
lordship. Lordship, I beg to mention item number 32 on behalf of SK Singh, senior counsel, lordship.
Yes.
Lordship, it may be adjourned for the day, and if lordship may fix it on 22, lordship.
Let the matter reach. These are hearing matters. Matter may not reach also. Okay. Yes.
May I
Okay,
please,
sir.
your lordship, I beg to mention criminal petition, 66619,
For what, madam?
admission.
When did you file? When it was last listed?
1965.
Okay, on 19th, coming Monday.
19.
Yes.
Lordship, I beg to mention item number 29, your lordship. I thought for instance accommodation, lordship, this matter may fix on next week, your lordship, anything on that.
Mr. Mohan, we're not passing any order at this stage. These are 2013 matters. Let the matter reach, we'll pass the order.
May I please, your lordship? Your lordship, I have two earnest prayers, your lordship, for listing of criminal petition, one for hearing and one for orders, your
We
lordship.
cannot fix the matter for hearing like this. It
Yes,
has
your
to come for orders first.
Yes, your lordship, one matter for hearing, your lordship, any date, your lordship, next to next week, your lordship.
It will not come for hearing. It will come for orders.
Yes, your lordship, orders.
Both the matters may come for orders.
Yes, your lordship.
You don't make it a hearing, you make it orders.
Yes, your
On
lordship.
22nd.
Your lordship, after 22nd, your lordship, there is a difficulty of the council.
27th,
Much obliged, your lordship.
May I please your lordship?
Sharma, for orders.
May I please your lordship? I beg to mention for listing of an IA for suspension of sentence, lordship.
When did you file?
On 8/11/23, lordship.
Since then, it has not been listed.
It was listed, the service is completed, lordship. Next week, lordship. Any date on next week,
27th,
obliged, lordship.
May I please, your lordship, I want to mention regarding listing of a criminal petition for motion on Monday, lordship.
when did you file?
23rd of July.
It has not yet been listed.
No, lordship.
Is it there is any defect on it? Have you checked?
Yes, Lordship, the defect, if
You have
it has
cured the
been cleared.
defects. You have cured the defects.
Yes, Lordship.
Monday. 19th.
Nineteen,
May I please your lordship? Lordship, on last occasion, both the parties have submitted before this honorable court that the matter has been amicably settled between the parties. And the complainant has received the entire cash, check amount. And for that, we have already filed an IA before the honorable court. Yes, today morning, under section 147 of NIA.
You have made a joint prayer or what?
Joint care, lordship.
You have filed today?
Lordship.
Have you filed okay.
Lordship, matter will be taken up after 1 week with the IA, lordship.
Do you have the filing number with you?
Yes, yes.
Can't you give it to us?
Filing number is IA criminal 7240 of 24.
There's a filing number.
Yes.
Please pass it on to us. It is submitted at the bar that both the petitioner and the respondent number 2 during pendency of this petition amicably settled their disputes outside the court. And to that extent, they have filed a joint petition today, being IA criminal number 7240/2024, which is not on record. What's your good name?
I Hussein, lordship, on behalf of PP Body Court.
Counsel for the petitioner. And you are Miss
A Roy.
Counsel for the respondent number 2. Also hard MS as Zahan an additional public prosecutor for the state respondent. List on 22nd, along with the records of IHS and such 7240. Take back this.
Macha, yes, lordship.
Not please, your lordship. This application is filed challenging the impugn order dated 3/11/2023. That your lordship will find page 86. Your lordship, the application filed under section 311 of CRPC by the prosecution side that was allowed. And here in this case, my ground is that lordship will find the charge sheet at page 17. In the charge sheet, your lordship will find 5 witnesses were named. And thereafter, lordship, they examined 6 witnesses, including and one Chandan Das lordship as PW6 by filing by oral submission that his evidence is required. So once they have availed that their remedy under section 311, thereafter what happened, lordship, the statement of evidence were closed and 313 statement of the accused was recorded at page 43. Your lordship will find 313 statement of the accused. And then written argument was also submitted by the accused side that your lordship will find at page 48. That written argument was submitted on 17/6/2023. And thereafter they filed, lordship, this application only on 6/10/2023. That once I disclose all my defenses, then they file this application to fill up the lacuna, lordship. And the last witness, PW5, he was examined on 15 November 2023. After about 1 year, they filed this application, lordship. When, lordship, we have filed our written argument only in that case. And if you, lordship, see the application filed by the prosecution side at page 81, nowhere they shows that for what purpose the re-examination of PW5 is required. There has to be specific reasons that these questions were left out or this part of the evidence is required clarification. That is not there in the application, page 81. They have simply said that witness, the below named witness PW5 SI Molin Bora, who is an investigating officer in the case, has been examined. But during the examination, some of the fact has not clear and to arrive at a judge decision of the case to clarify this fact, his re-examination is highly essential. So nothing is there for what purpose his re-examination is required. Because if his re-examination is done, lordship, then I have to examine all the witnesses again because I have prepared my defense in that manner. The documents which I have received, the evidence which they have laid on that aspect, lordship, I have cross-examined my witnesses. Now, if they brought now a new document which were not earlier filed to me, lordship, or submitted under section 207, then I will have to cross-examine the entire witnesses, lordship. Then it will delay the trial and cause prejudice to the accused, lordship. And even if page 87, your lordship, peruse the impugned order, last paragraph, it is also not there that what document they want to adduce. It is only said that certain documents and relevant materials have been left out. So if they brings new document, new material, then entire case will be diverted, lordship. It will amount to de novo trial, lordship. And exactly on this issue, lordship, that Supreme Court judgment is there. That's Sapan Kumar Chatterjee, lordship. Once I have filed my written argument, I have disclosed all my defenses on what point we have argued, everything we have disclosed. Now they have filed this application, Lordship. That has caused prejudice. And even in the order also, Lordship, that the main thing is that they have not said what document, what material they want to brought in the court, Lordship. Whether it was supplied to the accused or not, those things are not there. And for filing application, also, they have to be specific that on what point they want to re-examine the witness. Also.
Mr. Radha, take your. So, that kind of council appealing for the petitioner. And MS Al Zahan, an additional public prosecutor, appearing for this state. The MS Zahan, an additional public prosecutor, is also representing the respondent number 2,
Hmm.
informant of the case.
Informant is actually the reporter. No, Nikhil. No. SI, okay, now for him we can. The reporter said that I had informed, so PW number 4. Acha, PW3, I know the informant. Acha, I know the informant. Lordship, I can appear for you.
Reaching ASI Domoka,
Page PW1.
page 13.
PW1.
Number 7, Ranjit Singh, ASI Domoka.
That's one number 2, informant, who is a police person. The was serving as a sub-inspector at Doboka police station at the 11 point of time. The petitioner is agreed. Petitioner who is accused, suspected accused, in the special NDPS bracket of it, case number 24, within bracket H, oblique 2021, arising out of Doboka police station case number 448 oblique 2021. 22 the of the NDPS Act. And presently pending before the Court of Learned Special Judge NDPS Kirby Angle. On the basis of an application prepared by the public prosecutor, the learned special judge by order dated basis of an application dated 06/10/2023 submitted by the public prosecutor in said special NDPS case number 24/2021. The learned special judge after considering the matter by order dated 03/11/2023 allowed the said prayer of the prosecution made under section 311 CRPC and for re-examination of the prosecution witness number 5, the concerned investigating officer of the case. It is contended on behalf of the petitioner, asserted accused of that earlier the prosecution way back on 03/01/2023 submitted before the trial court that there is no further evidence to be recorded on its behalf, and by order it is 03/01/2023 the learned special judge in said special NDPS case number 24/2021 closed the prosecution evidence. Thereafter, the statement of the accused persons under section 313 CRPC were recorded by the learned trial judge. and after recording of the statement of defense, statements on submission of the defense counsel by order the 10/04/2023, defense evidence was closed and the matter was fixed for hearing. Accordingly, both the prosecution and the defense were heard don't know were heard. When the matter was the said liquor special individual such and such was in the stage of hearing of arguments on both the sides, the public prosecutor on 06/10/2023 in said special NDPS case number 24/2021 submitted an application under section 311 CRPC before the learned special judge NDPS Pajai for re-examination of the prosecution witness number 5, namely Malin Bora, Sub-Inspector of Police, the concerned investigating officer of the case. It is submitted by Mr. Azad and counsel appearing for the petitioner that the prosecution failed to place an irrelevant document before the learned trial court for re-examination of the said prosecution witness. And in absence of such explanation of the prosecution, the trial court should not have allowed the re-examination of the prosecution witness number 5. It is placed by Mr. Azad and counsel for the petitioner that in its application before the learned special judge filed on 6/10/2023 for re-examination of said prosecution witness in case number such and such. only mentioned that during the examination of prosecution witness number 5, the investigating officer of the case some of the facts were not cleared. And since it did not specifically mention the relevant documents for consideration, the trial court committed illegality in passing the impugn order dated 03/11/2023 in allowing the re-examination of the said prosecution witness. It is pointed out by Mr. Azad, counsel for the petition, that the evidence of prosecution witnesses were closed after a thorough examination, and there is no requirement for re-examination any of such prosecution witnesses. Mr. Azad also aware that the prosecution, by the process of re-examination of the concerned investigating officer, the PW5, will try to fill up the lacuna which they failed to place during the examination of the witnesses on their behalf. It is also pointed out by Mr. Azad, learned counsel for the petition, that though the prosecution examined one Mr. Sandan Das as PW6 in the said special case number such and such, who is not a cited witness in the surset, but the trial court, without applying the provision of section 311 CRPC, on its own allowed the prosecution to examine the said witness also. With the help of the same, the prosecution has now further developed their case and filed the said application under section 311 CRPC, dated 06/10/2023, for re-examination of the prosecution witness number 5. Only to divert the attention of the court from actual occurrence by incorporating manipulated documents and not in the interest of justice. It is submitted by Mr. Azad that matter is pending since long, and the prosecution by such re-examination of a prosecution witness wants to drag the matter further, by which the petitioner, accused person of the case, is prejudiced by the action on the part of the London trial court in allowing re-examination of the prosecution witness number 5 by the impugned order dated such and such. It is also placed before the court by Mr. Azad, counsel for the petitioner, that in the said petition dated such and such 06/23, 06/20, filed under section 311 CRPC. The prosecution did not mention about the existence of the authorization letter nor the said document, not those documents, were furnished to the accused, to the petitioner, the accused person of the case as required under section 207 of the CRPC. And it is the duty of the prosecution to submit all the relevant documents which it wants to rely upon during the trial. And that in such belated filing of an application for re-examination of prosecution witness, itself shows serious doubts, more particularly to the case diary maintained by the concerned investigating officer of the case. Which was not properly presented as required under the law. In support of his argument, Mr. Azad, learned counsel for the petitioner, placed reliance in the judgment of the Honorable Supreme Court in the case of Sapan Kumar Chatterjee versus Central Bureau of Investigation, reported in 2019-14 SCC 328. Wherein the Honorable Apex Court have held that italicized, where the prosecution evidence has been closed long back, and the reasons for non-examination of the witnessed earlier is not satisfactory. The summoning of the witness at belated stage would cause great prejudice to the accused and should not be allowed. And the court should not encourage the filing of successive applications for recall of a witness under the under the provision of Section 311 of the SAPIS. Yes, Mr. Azad.
Lordship, the next judgment is coordinate bench order, Lordship, that paragraph 18 and 19, that application has to be specific and documents has to be given to the accused side if they want to rely, Lordship. Only on that aspect.
Jogen Bora's case you are relying.
Lordship.
Mr. Azad. Is also relying on a decision of a coordinate bench of this court. In the case of Jogen Bora versus State of Assam, decided on 11/01/2018. Wherein it was held that it is the duty of the court, while considering a petition under Section 311 CRPC, that the stage in which such order under 311 is passed, that will not cause any prejudice to the accused, and that if such application under Section 311 CRPC is allowed at a belated stage, allowing any witness to be examined, that would ultimately frustrate and prejudice the case made out by the defense. And in such circumstances, the court should not allow any such examination of witnesses. has been paid under section 311 CRPC. Section 311 CRPC court করে দিবা। Heading to ভৰাই দিবা। Power to summon material witness. The Honorable Apex Court in Katina of decisions have held that under section 311 CRPC, the court enjoys a discretionary power to summon and any person as a witness or examine any person in attendance. Do not summon as a witness or recall or re-examine any person already examined. Where the power under section 311 CRPC must be exercised with caution and circumspection and only for strong and valid reasons. From the reading of the section 311 CRPC, it can be seen that it has two parts. First part relates to the power of the court to summon any person as a witness or examine any person in attendance. Do not summon as a witness or recall or re-examine any person already examined at any stage of any inquiry trial or other proceeding under the Code of Criminal Procedure. And the mandatory part is that the court should come to the conclusion that by examining or recalling or re-examining any such person comma his or her evidence appears to be essential to the just decision of the case. Has been held by the Honorable Supreme Court in the case of Chachatat Pradipal. The object underlying Section 3(1) on CRPC is that there may not be a failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statements of the witnesses examined from the other side. And the determinative factor is whether it is essential to the just decision of the case. And the said section is not limited only for the benefit of the accused. The discretion upon the court and is expressed in the widest possible terms, comma, the discretionary power under Section 311 CRPC can be invoked only for the ends of justice. Discretionary power should be exercised consistently with the provisions of CRPC and the principle of criminal law. And such a discretionary power conferred under Section 3(1) on CRPC has to be exercised judicially for reasons stated by the court and not arbitrarily or capriciously. From the reading of the Section 3(1) on CRPC, it is also clear that the court at any stage of any inquiry from a trial or other proceeding under the code summon any person as a witness such and such. In the case in hand, the state special case number such and such was pending at the argument stage. While considering the said application under Section 3(1) on CRPC, filed on 06/10/2023 by the prosecution, the trial court, after hearing the prosecution as well as the defense, and considering the said application under 3(1) CRPC of the prosecution as well as the objection raised by the defense. Came to the conclusion that though the authority letter was available in the case diary as its part, but it was not examined and when it was pointed out by the court to the defense, it was placed on behalf of the defense that the witness may be re-examined only to the limited extent and not to fill up any other lacuna, and that the defense may be granted adequate opportunity for cross-examination of the witness. The court, by the order dated while issuing notice call for by order dated 15/11/2023. Call for the records, scan copy of the records of said special NDPS case number 24/2021 from the court of learned special judge Rajin Baker NDPS Nakiba, Sankadev Nagar Hojai. And in the interim, kept the further proceeding of said such and such case in abeyance, which is still in force. On perusal of the records of the case, it is seen that the authority letters of the officer concerned are available in the case diary. Considering the fact that the learned special court while passing the order dated impugn order 03/11/2023 came to the finding that after hearing the submission of the party came to the finding that certain documents and relevant materials have been left out that are required for proper identification of the case. And accordingly, came to the opinion in allowing the application filed under section 301 CRPC by the prosecution, and thereby it should summon to the prosecution witness number 5 for re-examination or case re-examination. Investigation officer of the case for his re-examination. Directing the prosecution to take steps since the learned special court and DPS such passed the impugn order. The discussion and formed its opinion after considering the materials on record and on submission of the parties. Re-examination of the PW5, prosecution number 5, the concerned investigator into the case. That it appeared to the said court that it will be essential for the just decision of the case. This court is of the opinion that while personally impugn order that did not commit any illegal activity in violation of the provision of section 301. Accordingly, it is not a fit case to exercise the power under section 480. No, there is not a fit case to interfere with the said order as such and such part by especially the states. Needless to say, the defense will have the right to cross-examine the prosecution witness number 5, the investigation pursuant to the case on his re-examination by the the interim order passed earlier of such and such stands. The registry shall immediately attend such order. We shall forward a copy of this order to the court of London. Special Dutch anti-case, special case number such and such.
But before examining the PW5, those documents may be furnished to the accused side. That observation.
That always you can say under 207 you might have received it. If it was not there, you tell it before the court
And the
appeals.
judgment that he had shown where documents were required, in that judgment, documents were already exhibited. And he wants it to be further examined. Here, it's not even exhibited.
That's true. We'll differentiate that.
Yeah, there
We
is a
also
difference.
incorporate some judgments.
Oblige. Thank you, Lord. For it into application, challenging the proceeding.
The lordship will find that action has already been decided. This honorable court has granted stay in the proceeding. No, state the party. 294. The lordship will find the FIR at 322. May I read the FIR?
Just. Pick it. Yes,
Yeah, please, your lordship. Lordship will find the FR at page 22, lordship.
just tell me, Mr. Bora, one thing,
Okay.
the restaurant number 2
Lordship.
filed a petition before the London magistrate. That's Narazi petition, as it's
Yes.
popularly called.
Yes.
Do you have a copy of that,
No, lordship. That I do not have a copy.
Mr. Bora?
Well,
Though it
scan
is
copy has
mentioned
come,
that filed by 189-2023,
one scan copy of the record is there, my lord.
it is not available there. That's what I was trying to find out. This court was trying to find out only that petition. It's not available on the record. Mr. Bora, do you have a copy of that?
No, I am not positioning that particular copy, my lord.
You did not get a copy?
Lordship will apply for a certified copy because petition number 189 of
That's right.
23. We'll apply for a certified copy if required, lordship.
Do you have a copy?
And right now, lordship, I do not have a copy of that.
Miss Jahan, kindly go to the record and find out. Trying to find out.
Otherwise, it's a 294 everything on phone call.
Yes.
Clear. Ingredients of section 294, whether it's a public place or not, it is not there.
Otherwise, also, lordship, the words used are not obscene. Those are abusive words. In fact, the FIR also says that
No,
plain
that's
language.
506 because the cheating part is there. That is only thing. But ingredients of section 294, it has to be first a public place.
Yes.
Then obscene scene, other things will follow, but
Yes.
first it has to be a public place. The FIR clearly regulates
Repeatedly,
that
everything was done.
the unknown mobile number
Yes.
gave me a call.
Yes.
That's the FIR.
Yes. Everything was done over phone.
But things have changed in the new criminal laws.
Yes. Lordship.
Earlier, CRPC, of course, Things are different. Ms. Zahan, we are looking for that Narazi petition because it has to be different and it has to be specifically mentioned in the Narazi petition. Just simply saying that I have already filed an FIR stating that will not be the case. In a Narazi petition, the person concerned have to very specifically mention.
The petition is like a complaint, he can state.
He has to give details.
Ah.
He cannot, whoever the applicant in Narazi petition, the protest petition, the protestant, the complainant must be very specific. That's why I want to look after that, because otherwise the magistrate on that kind of protest petition could not have acted upon it.
Further investigation by a different officer.
It's not there.
No. It should be in the record because 189.
No, it has been mentioned, but probably may not be available in the record. Otherwise, everything has come. Yes, Mr. Bora appearing for the respondent number 2, kindly tell us, as you have seen from the FIR, that it was from an unknown mobile number. The respondent number 2 was threatened by some person. Now, the first ingredients of the section 294 is it's a public place. In that case, what will happen?
Let that particular document.
No, that,
Document come-
forgetting
come-
about that issue. Now the charges have been framed, cognizance have been taken under section 294
Only.
by 506. 506 because of the sitting over the telephone.
Not so.
But 294, before that 294 has to be, where is that? Kindly tell us. FIR doesn't disclose any ingredients of section 294.
That is it's a telephonic conversation.
Had been under new criminal laws, it would be different.
This one is there, the application.
Is it 189 numbered?
Oh, no.
Yes, 189.
189.
Just let us see, I didn't get it.
Two-line order,
And that
two-line
is,
application.
that is not possible.
He has.
The law is very well settled. In a
His-
protest petition, the complainant has to make the specific allegations. That's the law.
Yes, complainant wants to contest the case, as such the
Yes, one.
police report be not accepted.
No,
An order for reinvestigation by higher officer, that's it.
cannot be.
Hence, the complainant is ready to prove his case by producing documents. See,
Nothing.
this is.
In a protest
two-line-
petition, the complainant must be very specific. In fact, in one of the case, Honorable Apex could have clarified. If you see
Behind
that
the Wakalat that's why it didn't indicate.
behind you.
Behind the Wakalat.
Last page of the document.
Okay, they have saved the paper. Cannot be. Then one of the
Not true,
apex, that is the
not
decision
true.
of the apex court is very clear. What happened, the complainant by filing the protest petition, it's just 5-line protest petition saying that I have already filed a complaint petition. I reiterate my thing and it has to be considered. It was acted upon by the magistrate. The matter went up to the apex court. The apex court have
That judgment I have not seen.
very old.
Acha.
That's the reason. I'll try to get it for you. I read it, that's why I remembered.
I will also go through this, my lord.
Yes.
In fact, in that
Yes.
judgment, Apex Court says that the magistrate has to see on what aspect the investigation has not been carried out.
Here, further investigation is allowed because
See,
further
the,
thing 173 is
magistrate has the superintendence under section 156(3).
Okay.
The magistrate can supervise the investigation, no doubt about that. But to act upon a protest petition, the what you
Yes.
call the Narazi petition, it has to be very specific, first of all.
Yes.
Secondly, ingredients of section 294 from the FIR itself, it is not there. They specifically mentioned that unknown phone number, unknown mobile number. You was threatened. So, and that is why if you are just going through the report, the final report submitted by the police initially, that was the reason why the investigating officer came to the conclusion. Okay, we'll deal with both the matters. No ingredients of 294.
Lordship, let me examine the entire law. My Lordship, fix it in another. I have not gone through this particular.
Okay. 22nd.
22nd.
Mr. Bora, both Mr. Boras. Talking about.
Both.
Okay. D Bora, S Bora.
R.
We'll
Bora.
have it on our.
R.
We'll
Bora,
have it
S.
on,
Bora.
we'll have it on 22nd.
Lordship.
Okay.
Lordship, interim order will be something.
Yes. On the player of- Miss Jahan, that judgment I was thinking, it was long back.
50?
It's very old judgment, and there, why I'm telling you, it was the days when the AI had, just like the mobile phones earlier have that a slip. You have to scratch it, then by pencil, then you get it that phone, that particular number. Earlier, the mobiles were charged in that manner. Did you remember those
Yes,
days?
yes,
Right?
yes, yes.
Similarly, air also, air, what was weekly? Air weekly had that provision. They used to give you a slip. If you tear it and if you scratch it, then you will get a number. You have to incorporate it and then you will see the decisions. It was just like that earlier. There, while it was that process, I still remember that we read that decision in the air. We have to find out whether it is available in.
So it has to be
It
before
was 69.
69.
No,
Before
because sometimes in that decision is old, but sometimes in 90s we have control.
Okay,
80s and 90s sometimes.
I'll find out.
Okay, Mr.
Yes.
Around 27. Interim order, Pakistan. Nothing to worry about.
Okay.
Supplementary 34.
Lordship, matter may be adjourned for the day.
For the day.
Sorry.
Reminders were issued to, for getting the records.
it has come.
Records are here.
Records are. You have filed your objection, I believe.
Yeah,
Objection was filed. Is not it?
perhaps by the private parties.
Not by you.
I don't remember.
It will be only question होगा.
123. Apple preservation. No conking. Hey, go mafia. 79, 411. 923.
In spite of issuance of reminders, the registry is yet to receive the records of criminal appeal number 14/2022 from the Court of Learned Session Judge Dhubri.
No, reports are here.
No,
Oh, acha, acha. 3 files.
but the office note says something else.
Oh,
Just me. So I think. But ACR, LCR, it is really good. So, surprise. Is him of right. GR explained. Inspector Vishnu reminded. The registry is yet to receive the records of criminal appeal number 14/2022 from the Court of London Session Judge Tilbury. That was dismissed on 06/01/2020. List on 29th. Don't make it 29th, make it 3rd September. Failure on the part of the authorities concerned to provide you the records of said criminal appeal number such and such. Disposed of by London Session Judge Tilbury on such and such. The court shall consider to pass consequential order against the erring officer. Registry shall forthwith communicate this order to the London Session Judge Tilbury. Registry has already received the records of PRC number 1735/2023. Reference is here case number 663/2023. 2022, arising out of Gauripur Police Station case number 182/2022 from the Court of London Judicial Magistrate to 35.
Oh.
May I please your lordship? Lordship, it's an application under section 528 of BNSS for quashing the proceeding of sessions case number 245/2022. Lordship.
The
Lordship, grounds for the quashment of this petition.
when the FIR was filed,
FIR in page number 12, Lordship. Original FIR is in page number 14. Lordship, FIR dated 9/6/19. Lordship, please have a look in Annexure 3, page number 31. There is a marriage certificate.
where
Dated
is the
5th
FIR?
June-
Where is the FIR?
5th.
FIR.
Translated is on page 12.
Yes, page 12. That's Nanti bisa naik. Culture bisa naik.
That is complete one. Opposite party.
But only set. It's a joint petition.
Yeah, it's for an victim.
50 में itself petition.
Oh, joint petition.
Joint petition.
Oh, compromise.
Compromise. Husband and wife are policy.
There is a compromise between the parties.
No, where is that? Want to see the FIR? That's why I'm not getting it.
They got married. After that, there were physical relationships. Then she was driven out of her matrimonial house.
council একটা নতুন step করে এখন step টা এই করে। ঠিক আছে, এখানে লেখা হবে আর কি। না লেখা না লেখা, no problem. What is the stage of proceeding?
Initial stage, Lordship.
Cognizance
It's in
taken,
the appearance stage.
cognizance taken
Not
on
yet,
the charge sheet.
not yet.
Settlement before the charge sheet, after the charge sheet, during trial, considerations are a little different. But here, it is at the initial stage, as he is saying.
বিয়া বহুত হৈছিলে
বিয়া হৈছে এইটো।
পিছত মানে এফাৰ হৈছে গতিকে 376 এপ্লিকেবল নহয়
দিছে জানো?
কিন্তু এপ্লিকেবল নহয়
Yes, you have filed this application under the BNSS, right?
Lordship.
Can you read the provision of section 531?
Oh, BNSS, BNSS, okay.
The repeal and saving clause.
And those are like, yes, the trial or whatever is going on.
Application and everything. That's what, whether it will come under BNSS or under CRPC.
Oh, yes, even that came to my mind initially. And I thought, huh?
Kindly read, do you have a copy of BNSS? Okay.
I have.
You have, ask him to read.
Ah, yes, I'm just taking out saving
531.
clause.
531.
531, yes. It was Oxford. Was it nine? If immediately before the date on which this Sanhita comes into force, there is an appeal, application, trial, inquiry, or investigation pending, then such
Appeal, application,
same
trial,
thing.
enquiry,
Even
investigation.
As given in accordance with the provision of CRPC. It came to my mind initially, but
That
thought it's a new application.
531A1 is very clear. It has to be under CRPC, not under BNSS.
I filed under CRPC, but they corrected it under BNS. That's why it is handwritten, Lordship. You can see it in the first page.
Acha.
I corrected it by writing in hand.
By showing it to the registry, he can file afresh his application. No. It will definitely worry. To the investigation, trial, inquiry.
It's done.
Lordship.
Page 11. Signature of the petitioner number 2.
Hmm. Yes, and in the,
Come to page number 31.
and in the 51. Falguni,
The agreement of compromise
hmm,
and the Okalatnama.
D is different in all.
Everything P is different, D is different. Compare it to 31.
Gap बहुत है actually.
Huh?
Gap बहुत है. 17, 18, 24 बहुत बছৰৰ gap মানে signature বিলাকৰ. এখন recently হৈছে.
He's saying there is lot of delay from the point of filing of the FIR. But then
No, we are not
P-
on that.
P
Is
is
this
little same. P is like, there is a curve at the end. Faguni.
you compare it 31. 31 is the original, right?
31.
31 আছে আপোনাৰ
31,
2009 not
that signature doesn't tell you to anyone.
This is totally different. But the compromise and the affidavit is little same. And what my learned friend is saying, because this is at a later point of time.
And the affair is in Assamese, that's what. Signature is also in Assamese.
Lordship can call for personal appearance of.
No, again, somebody has to identify her.
Oh.
We can ask the police of the particular.
Hmm.
Khetri police station to just to submit a report whether
Yeah,
she has filed this affidavit.
That is the best way out.
Heard Mr. Aswad, counsel appearing for the petition. Petitioners NMS as Jahan Lanedison, prosecutor for the state respondent. The petition number 2 on 09/06/2019 lodged the written azhar before the officer in charge of Khetri police station against the petition number 1 and 4 other persons. Of assaulting her by them on her reaching the house of the petition number 1 on being called by him at night around 10:30. On 08/05/2019. And throwing her out of the house of the petitioner number 1, with whom who is her husband, and both of them were married on 05/06/2017 before the marriage officer Kamrup Metro Assam Guwahati under the provisions of the Special Marriage Act 1954. Pursuant to the said FIR dated 09/06/2019 of the petition number 2. Petri PS case number, police station case number 100/2019 under section 120 oblique 420/376 406 341/325/34 IPC registered and search sheet in the case was filed on 30/04/2020 under sections 120B/420/376/406/341/325/34. Under 120B/420/376/406/341 against the FIR and accused persons of the case, including the petitioner number 1. Against the petition number FIR and accused nil. The both the petitioners later Tarakote Arata. Ms. Jahan, please come to page number, probably we can allow this. Come to page number 33. This is the Then come to page number. Page 35, clause 7.
This is mutual separation.
Then you come, that is what, clause 7.
That by this agreement, if there is any pending case filed by any party, the case will be withdrawn by the parties at the earliest.
Now please come to page number 38. Read the first portion of the order.
Direct মানে কই টাকা নাই?
নাই টাকা, কেবল দিছে।
সোয়াই নাই মানে।
হ্যাঁ,
38 Lordship, yes, the incident between filed by the petitioners under special dissolution of the marriage.
Then we carry on. The case of the petitioner.
The case of the petitioner is that marriage was solemnized on 5/6 before the marriage officer. Out of their wedlock, no child was born after their marriage. Due to differences in temperament, habits, so and so, the relationship between the petitioners deteriorated and there is no chance of reconciliation between them, and both the parties started living separately for more than a year. The marriage had broken down irrevocably due to irreconcilable differences, and there is no scope of reunion amongst them. Hence, both the parties mutually agreed that the divorce should be dissolved on mutual consent by agreeing that the petitioner number 2 shall not claim any financial benefit, maintenance, or a permanent alimony in future from petitioner number 1. It is stated that both the petitioners have agreed to withdraw all the cases filed against each other. It is stated there is no false fraud, so and so. Hence, it is spread.
Now, that is the, if you go through that particular affidavit, agreements at page 33.
And there will be no alimony, nothing, no financial benefit.
No, what we are saying that page 33, 34, 35,
Yes.
up to 36. You can see the signature of the respondent number 2, petitioner number 2. Same as that of
That of the settlement.
affidavit, page number 11.
But yes, according to the affidavit, it's same.
And then also the agreement that you have next here.
But FIR is different.
FIR is in SME, but it is same kind of signature. Probably will allow.
FIR law before almost 5 years, 4 years ago.
Or if you say so, we'll get the report that much.
Only in the certificate, the signature is little different.
Only in the certificate, but that is why clause 7, whereas clause 7 of the affidavit agreement before, and that was also been recorded by the learned family court.
Hmm. In the FIR, the signature is an Assamese, so it is
In
different.
the FIR SMEs and the marriage certificate, signature is little different.
It is English.
But we can get a report from the investigating officer if you want.
But they have decided to withdraw all the cases here.
So that's what's there. That is the same affidavit.
Principal by the family court already. By mistake we got. Separation, separation. Without separation.
The both the petitioners, both
They are married and staying.
petitioners, including the informant of
She is not married.
informant victim of the Kaki PS case number such and such corresponding to such and such. PRC number 2156 of 2021. Reference year number 8555 of 2019. For presently he is subsequently and the said case is presently pending. The FIR was GR case for GRC case for now pending assistance case number 245 of 2022 before the Court of London Additional District and Session Judge FCC number 4 by its joint petition. The both the accused of said PRC case, case number such and such. And the informant victim jointly pled for causing of the proceeding, procedures in case number such and such. Arising out of PRT case number such and such corresponding to PSA, PH case number such. Right. Before proceeding further, we direct the investigating officer of Kaki Police Station case number, sorry, Petri Police Station case number 100/2019. To re-record the 161 CRPC statement of the informant victim Namtu Paradiva, petition number 2. Relating to the fact that he has already compromised the dispute along with the accused petitioner number 1, Namtu Paradiva. And to that extent, he has entered into a compromise agreement with the petition number 1, Namtu Paradiva, on 16/07/2024 before the notary Amrup at Amingaon, and has filed a present criminal petition. Such report shall be placed before the court by the concerned investigating officer of the case number by 6th of September. Okay. List accordingly on such and such. Copy of this order be furnished to MS Azam, learned regional public prosecutor, preparing for the statute. Get the report.
Yeah.
That will, otherwise we would have person, but without.
Yes, highly obliged.
For orders, item number 47.
That yesterday, madam. P26 only 34. He person they are in custody, my daughter.
Just a minute. That's all. Please check.
Public visiting. Public visiting. Well, I'm going to visit. Doshma building. Appeal of petition. Appeal.
Mr. Chaudhary, please take it.
Nine.
Mr. Chaudhary, when the petition number 1 and 2, applicants number 1 and 2
Yes.
were granted bail earlier during the trial?
No, all the three, madam. All the three, madam.
No, they were arrested.
Yes,
But,
all the three were arrested.
but when the 1 and 2 were released on bail?
Yes, 1 and 3. Your lordship will find page 13 of the IA. Page 13 of the IA. Your lordship got it. Different dates, man. By this time, he was, number was released on 2/3/16. 2 also 2/3/16. And 3 is matter 4/10/16. Release.
3 is the longest period.
Longest period.
1 year, 7 months.
1 year, 7 months it was. Now, taking present one. Although there is nothing against 3 mile.
Yes, Mr. Sharma. We'll allow him. Basically, it is the applicant number 1. Other 2, they are. And what we have seen that the number 3 applicant. Yes. From the records, we have seen that he was taken into custody on 15th of March 2016. And the bail order was granted by this court on 29th of September 2016. After more than 6.5 months, he was and after he was released because bail was not there. So he could be released only on 4th of October 2016. But the materials will reject against the
Against
number
1.
Against
Some
one,
materials
my
of this.
and the number 2 and 3.
Yes.
Yeah.
So 1 also, I think, my your lordship. May.
1 because there are
Yes.
eyewitness to the incident. And if you read the evidence of the victim,
Mana IO, if you look, can you say IOs, my lord? Your lord, can you see Spiegel PW 8 mile? PW. I'm giving a Spiegel, I'm having mine.
no, we are having, the record is before us.
Yes. So now like that. 8 your lord's kindness, my lord. 8. PW 8.
But the victim has clearly mentioned that.
That is there, but whole question my lord is actually, in fact, actually, whether the accused number 1 is the author or some other persons, my lord. Hundreds of people came.
He called him to his house.
And 161, your lordship, nothing against accused number 1. 161.
That is confirmed to IO.
Confirmed to IO. And the bit of the IO, my lord, it will make clear. 161 contradiction.
Page 44.
Page.
Amar 44.
Amar page 44. Yes, ma'am. If you will kindly come to IO's cross mile. English already translated copy of here. That is available, paragraph 17 of judgment also.
Read the second para of the cross-examination.
Yes.
PW2
PW2.
is the victim.
No, I am, A, contradiction, 161 contradiction, I am saying. Ayo.
Finally,
Yes, because I have mentioned that
yeah.
second paragraph. I have mentioned the height and measurement of the PDS organization. PW2, your loss kindness. PW2 Hormuzali never stated before me by which he identified the accused. The source of identification was not mentioned or stated by PW2 on the Hormuzali. Yes. No. Close up. Then you will come look at the page next, my lord. PW2. Hormuzali never stated before me that the accused Muhammad cut the fingers of his left hand by dagger. Accused Sarveshari injured him while he was examined by me and so on and so on. PW3 Abdul Kalam also stated that the accused so and so. Musammat Malika Khatun never stated before me that the three accused person called her husband so and so. The face of there is some doubt, my lord, at this stage what I mean to say. Something is there. In fact, what he has gone is a sannyasi, and he wanted to have my 1 lakh rupees, otherwise that God will kill him. That is the allegation. He made he and cry, and hundreds of people came. And how this happened, my lord, he may not be the author of the injury, my lord. Anyway, I lift your lordship at this stage because I find my lord, there is some doubt about the one also.
Yes, Mr. Sharma.
Yes, my lord, from the statement of my lord, PW2, my lord, that allegation against my lord, my lord, accused number 1, that is my lord, that is established, my lord. So my lord, except my lord 1, my lord, there is 2 maybe considerable.
161 no, 61, PW8 is just. He never stated. Paragraph 17 was judgment. 17 was judgment. Court also might have discussed it.
But in the 161, I don't know, it was not brought out to the notice by the prosecution. But I have, in the 161, the victim clearly mentioned that these three are the accused persons, and he was going with it because it is the applicant number, the petitioner number 1, Rahom Ali.
Yes. But
He called him and he was going with him. And then the sugarcane field, the Rahom Ali, Batsa Ali, Sarvesh Ali, one Noor Hussain. All together they have this thing.
That is, but I am
That
just.
is in 161 of the victim.
Noor was not considered.
Not succeeded, but this
yes.
victim clearly mentioned that on date, giving the date also.
Yes.
That where incident took place, who are the
5.
persons who have assaulted him.
5-2.
Then
and if your lordship share, then at this stage, petition number 1. But ultimately, because IOS cost, it is brought on the record. Contradiction. That cannot take that thing. Medical intervention, my lord. Medical was done prior to identification, prior to the requisition of police. Whose medical was done?
nobody, no police personnel took him to the.
No.
Because FIR was lost 3 days later.
But 3 days, but medical was done, your lordship will find. That was on 12, medical requisition 12 to 15. 12, 15. Your lordship kindly say pay 6. PW 6, man. Clearly he stated, man. PW 6. PW 6, your loss will find. Cross. Patient was not identified by any person, your lordship. Dr. Myla, he self-appeared before me without police escort.
Yes, that you have seen.
Police requisition submitted later on 12/12/15. Then how much on what basis might have that will be attributed to this person, man? Thereafter, he also stated, my lord, that such type of injuries may be caused by falling against multiple sharp-edged weapon. In the plant sugar cane, my lord, he was found. He himself said.
Not the petition number 1.
I lift your lordship, my lord, at this stage.
At this stage. But the other two will be granted. Take it out. And it won't it.
Your number 1027.
Satisfaction of additional session judge, Fast Track Court, North Salmora, Oyapuri.
Yes. No, so where? In sessions case number?
That will give,
Right.
sessions case number is 42A.
42, you can make a capital S.
Capital A/2026.
That's right. Navapuri Police Station case number 354-2015.
And about one at this stage, you lost.
No, but at this stage only. For one, it will be at this stage only. It's a criminal appeal, 10 years, we know.
Yes, that is the one.
Okay. At this stage only for 1, but 2 and 3 will allow.
We will get today, my lord, that will be available.
Today you may not get because now there is a meeting, I might try.
Problem is, my lord, his daughter is in hospital. That's why
We'll
I'm.
try to get it.
Yes.
We'll try to, otherwise tomorrow morning.
Obliged to us.
Okay.
Day after tomorrow or any other day?
Okay, we'll consider. This submitted by Mr. Das, council hearing for the petition. Slash. Appellant. That. The interlocutory application has been filed. For providing the new proper address of the accused persons, which is not before the court today. You have the above, list this matter. $59. Please. No, yeah, 29.
Good afternoon, my lordship. My lordship,
Yes, ma'am.
I am the petitioner in person, my lordship, for today's matter. Actually, my lordship, I am victimized by the instant affair, my lordship. The instant affair is the actually cross case, my lordship, against my main case 572/2016, my lordship. Only launched the cross affair, my lordship, to save himself from his total fraudulent, my lordship. So, my lordship, it is actually liable to dismiss of my lordship, dispose of my lordship. My lordship, my instant affair and instant IA is filing, my lordship, because of one order from Chief Judicial Magistrate has passed on 9/11/2000, 9/11/2022, my lordship, that on order has written that their total their LCR of record of LCR from Honorable High Court has sent back to concerned court, my lordship, but there is no any such order like such order from Honorable High Court, my lordship, because after 7/2/2020, my lordship, and subsequently 7/2/2020 for correction, some typographical correction, one IA was filed on 10/2/2021, my lordship. And that is also, that's order also submit before the Honorable CJM Court, my lordship. But there is no any such order, such like order to send back, my lordship. So I feel to file a IA, my lordship. Now, my lordship, may I pray to stay pass pray to pass a order for stay the proceeding of LCR 8143/2016 and also may I pray to call for the original copy of LCR, my lordship, because otherwise it will be occurred a great injury, unrepairable injury, my lordship, for me. And in the LCR statement, all witnesses statements from all witnesses statement has cleared that this is the they all has admitted that this is the cross case, my lordship. Actually, I had to purchase one plot of land, my lordship, from instant FIR petitioner for the consideration total amount 30 lakhs, my lordship. And he had taken money 15 lakhs from me, my lordship, before sale permission. And after taking sale permission, he has denied to give me the land. And accordingly, he was compelled to make a compromise deed, my lordship. Initially, I was not agree, but cleverly he go to my husband had to convincing the matter to make compromise deed, my lordship. And accordingly, compromise deed, my lordship, verbally it was decided to return with interest, my lordship, 20 lakhs, but cleverly he returned in 18 lakhs, my lordship. I was unable to seek, my lordship, because of my son was so small at that time, my lordship. But he has not returned my total money, my lordship. When I asked him to return, asked to keep my money, then he has always practiced to threaten me. And one day, in front of Guwahati University High Court, Guwahati University gate, he attacked me with 2 persons, my lordship. At that time, my baby was also with me. And he threatened me that if I asked to him to pay the amount, then he will kill me and he will kill my family. My lordship. So I was compelled to launch a FIR, my lordship, before the police station, Jalukbari police station, my lordship. Actually, from the initial stage, he was applied some technique to sitting me, my lordship, because after getting their self permission, after expiry of 3 months, he had given me the self permission, my lordship. Actually, I am victimized, my lordship. Now he's in this FIR contents are totally false, contracted, my lordship, baseless, my lordship, in his FIR context.
Who is appearing for the respondent number 2?
Yes, you are appearing. Utha.
My lord, I'm not appearing. I'm on behalf of A.T. Sarkar, my senior leg in another court.
My lord. May take leave for some moment, my lord. One matter is there. Learned counsel.
List on Friday. Date to Friday, 16th. Along with the records of criminal petition number 1513/2019. Referred by the petition. Presently pending for adjudication. Yes, ma'am, it will come upon Friday along with the other case. We'll consider your matter on that day. Your IA. Make a mention in the morning on Friday. We'll consider it.
My lordship, please
Friday.
stay, pass and stay order.
We'll consider because there is another case pending. We want to see to that. We'll consider on Friday. Don't worry.
Obliged.
Morning. 7 you paid for time, no? Pay for now.
Lordship, I am for the petition.
No, this is to say, it's not obvious, no? Okay. What is it? Where is it? The opposite parties are not here, but. DK Kothari. Jen. Pratibha Islam. Oh, you said he was there.
Someone was there in the morning, right?
Huh.
You made a mention.
A young junior boy, I think.
He was there.
No?
Lordship, after my name.
Acha.
Dilip Kothari's son.
Yes, ma'am.
Oh,
Yes.
Do by order dated 1809-2023.
yes, challenge 89.
The court
17.
all for the records of
Oh,
CRK scan copy of the scan eligible copy of the records of scan copy of CRK number 1076C public 2017. Pending before the Court of London Judicial Magistrate First Class Kamrup Metro Guwahati.
এখন কিতাপ শুনলে একটু নাম
And further,
পুরো নামটা নাম কথা
order was issued on 18/07/2024 for issuance of reminder to the Court of the State Magistrate for the said record. But office note dated 09/08/2024 reflects that in spite of issuance of reminders, registry is yet to receive the said record. The registry shall issue reminder to receive judicial magistrate Kamrup Metro Guwahati as well as the judicial magistrate Kamrup Metro, judicial magistrate first class Kamrup Metro Guwahati for the records of said CR case number such and such. Right. 1076C 2017. List on 2nd of September. Failure on the part of the authorities concerned to provide with the records of said CR case number such and such. Pending before the court of law and JMFC, Kamrup Metro Guwahati. Case number providing. The court or to provide eligible scan copy by the next date fixed. The court shall consider to pass consequential order against the erring official in obstructing the adjudication of this case.
Viva? Oh, POXO matter, although notice is complete, but
It's complete, yes.
nobody has appeared. Lordship can appoint an amicus in that behalf.
Notice has been served on her mother.
In fact, if
Yeah, he
we
is-
go by the new law, then even a female member will do. But
Earlier,
earlier it has to be a male member of the family.
Mother
doesn't-
says
doesn't-
informant man. Examine as a PW. one.
Mother is the informant. no?
Informant, yeah.
Oh, she is the informant. It's okay.
the sin that in spite of service of notice on the informant respondent number 2. The said respondent has not appeared in the matter. Considering the above. Have you filed any objection?
Objection
Yes,
is there.
let us file one item.
Filed by my learned friend Anjuara Begum.
My lord, the core allegation of the prosecution
Just
is
a
that-
minute.
Hmm.
Yeah. লিখখন লাগে।
Thank you.
Objection আছে না? I don't see it. I am that here.
Because in spite of service of notice on the respondent number 2. The complaint informant. The said respondent did not enter the appearance in the matter. Considering the above. Srimati Manisha Karen Brown. Legal aid counsel of this High Court has been notified by notification number 23 dated 18/04/2024. And appointed as such and such for the said respondent number 2. Informant of the case. Registry shall provide her already requisite all necessary documents, including the application I liquor such and such, by which the convicted accused have prayed for the suspension of the impugned order, judgment about conviction, and sentence dated such and such. List on 2020. Registry shall reflect the name of such and such in the cause list for the respondent number 2 as their minus. It will come on next. You make a mention in the morning, we can take it up in the second part.
Next.
Extra tea to washing it. Yeah, sit. Nalagi get over the
I'm behind the bar for my lord, 1 year, 3 months, my lord. 4 months, my lord. And earlier I was behind the bar for 3 months. Thereafter, judgment was passed on 13/7/2023. Now I am behind the bar for my lord, 1 year, 4 months. my lord.
Objection filed.
Yes, my lord.
Lordship, yes.
Everything is available, my lord.
Amicus is also there for that.
Amicus is also there.
When the objection was filed.
It was filed on my lord, 15/7/2024, my lord.
Objection.
How come it is not on record?
15/7/2024, my lord. Copy is available with me, my lord. That is the objection.
Other way, office is showing, office not showing that not been filed.
Acha, it's not in the records.
No.
It was filed by my learned friend Bankim Sharma. It's always copy is there with all the parties.
That is the office note.
Mhm. Perhaps it's lying in the bench section or wherever.
Your lordship, here
Do you
the
have the filing number?
I received on so and so.
municipal.
Oh, yeah. So it was filed perhaps on 15th of July.
How come it's not on record? Very surprised.
হেৰি চাব পাৰি না চাওঁ এইটো মাৰি চাওঁ
এই ৱেবছাইটত নেদেখাব চাগে দেখোন নাই একাউণ্ট
এইবিলাক চাই নাজানো
দেখাব চাগে ৱেবছাইটত দেখাইছে
চাব দিছোঁ চাব দিছোঁ
নাই নেদেখাব চাগে একো নাই যদি
মই ইমান এক্সপাৰ্ট নহয় যোনে expert হ'লে। Huh? My lord, as per my lord, document detail, written objection was filed on 15/7/2024, my lord.
সেইটোৱে হ'ব 15/7 the day when it is served upon the
Where from you are getting?
In my mobile phone, my lord. We have got-
Criminal.
IA criminal 790/2023.
That's where we are there. That's where we are there. এইটোতো আহে। Just file. It's there.
Oh, the state of some way to.
But somehow that is not before us. Anyway,
Yes, ma'am.
yes,
Yes, well. May I go, my lord?
yes, yes.
Yes, well. Here in the instant case, my lord, first point has to be proved, my lord. The age has been proved beyond all reasonable doubt. The girl has been below 18 years. My lord, in this case, what happened, my lord? In a nutshell, I am submitting before your lordship that they have produced a transfer school certificate, my lord. First school certificate was not produced. And there is a judgment of, I will come later on, judgment of the apex court, Jugraj Singh, my lord,